to VPG's Virtual Water Cooler Chat podcast, a platform that celebrates the rich tapestry of professional diversity, with a particular emphasis on empowering women. We aim to foster diversity, equity, inclusion, and accessibility, DEIA, for all, while recognizing and championing the achievements of everyone as a central pillar of our journey. In our conversations, we explore a wide spectrum of backgrounds, experiences, and perspectives, creating a vibrant mosaic that enriches our collective understanding and strengthens our commitment to diversity and empowerment. We have the pleasure of having VPG's very own litigation assistant, Kiana Solomon, to chat with our guest, Michael Flanigan. Based in San Francisco, Michael G. Flanigan assists clients in technology and intellectual property litigation throughout the United States. He has broad experience in federal and state courts, including post-grant proceedings, inter parte reviews, and post-grant reviews before the Patent Trial and Appeal Board and Section 337 proceedings before the International Trade Commission, ITC. Michael focuses his practice on complex civil and high-stakes intellectual property, high-technology litigation in both state and federal courts. Michael's practice centers around intellectual property litigation, including pretrial strategy, patent and trade secret enforcement, patent defense, patent consulting and monetization, and patent portfolio analysis. Michael utilizes his background in electrical engineering and computer science to advise tech companies in cloud technology, consumer electronics, telecommunications, software, computer architecture, medical devices, and other technical fields. Michael's practice also encompasses complex civil disputes such as contracts in business, real property or land disputes, misappropriation of trade secrets, copyright and trademark disputes. Prior to joining Crowell Moring, Michael spent nearly a decade in private practice at elite national trial law firms, where he represented clients in high-stakes patent, trade secret, competition, and complex commercial disputes through trial in the fields of cloud technology, consumer electronics, telecommunications, software, computer architecture, and other technical fields. Let's get started.
Thank you so much for coming on. How are you doing today?
Doing well. Thank you for having me. It's a great opportunity to talk with you, and really appreciate the just time to sit down and talk about, patent law, my career, and everything.
Yeah. So thank you to Ashley also and VBG for bringing us together. Do you want to start by telling me how you know Ashley and how you guys got connected?
Yeah, absolutely. So at my previous firm, Reichman, Jorgensen, Lehman, Feldberg, Ashley and I worked together on a particular case, and she was the one basically managing and handling all of the kind of like filings and everything for the case. And so she's awesome. Very helpful. And as a matter of fact, we had a good outcome for that particular case. So kudos to Ashley. So we go back a long ways.
Awesome. So would you mind telling me a little bit about your earlier career, maybe starting from when you got interested in science and before you even discovered law? How did you get started on your academic path?
Oh, absolutely. So actually, it started early on. My brothers had me heavily involved with remote control gas cars and helicopters. And basically, I was building these cars remotely. And that's what kind of started the engineering aspect of it. And so I got involved with math and science, and also a little bit on the video game side, because as you're working with software and the hardware, particularly like Atari, Nintendo, Super Nintendo, you're always trying to figure out how does the code work on the background. And even PC games were big at the time, particularly Doom, Conan, and kind of some of the other massive multiplayer video games, online video games. And so that's kind of what got me started into like the engineering, the software, and the hardware aspect. And so when I went to undergrad, North Carolina A&T, I studied computer science and electrical engineering, and merging the two together, that's when I kind of got more involved within networking or communications. And so I went to grad school for USC. That's where I focused on more network communications, particularly like network video games, and network devices. And so, I've had plenty of professors, teachers kind of like direct me in that direction, in that vision. So which is great.
That's such a misnomer that video games will sway you academically in the wrong direction. It did quite the opposite for you.
Yes, absolutely. Absolutely. I mean, games have been, especially over the years, they've gotten bigger and better, particularly with graphics, multiplayer. Now it's just a huge, and now with cell phones, it's just a huge industry.
Now with VR.
Yes, yes, with Vision Pro, yep,
Yeah.
and the Oculus. So
Yeah.
it's going to continue to expand.
Yeah, absolutely. So how did that transition into a career in law?
Yeah, so it's interesting. During undergrad, as a matter of fact, a couple of my friends, we took a class with Kimberly Gatling, who was a patent attorney at the time. And she kind of exposed us to patent law and what it had to offer, particularly if you had an engineering background, which all of us did. But my friends actually went to law school after undergrad. And then I went to do my master's in engineering. And then after graduating with my master's in engineering, I went to work for a company, a medical device company in Minnesota. During the time, it was very competitive, particularly what devices that we were working on. And so the competitors sue each other over patent infringement. And so that kind of ignited the fire again to pursue patent law. And so after working at the medical device company, I went to law school after that.
Were there any figures in your life, like mentors or family members or teachers who influenced your career choices?
Yeah, it was my group of friends, a couple of them being like Rashad Morgan, Shane O'Reilly, Jason Hayes, and Chris Richardson. They're like, Mike, you really got to look into patent law. You know, it's a great field, it's a great career, particularly with your background. You know, you'll have a lot of fun. And what I liked about patent law is you get to dive into different aspects of technology. So, for instance, you know, you're working with software, you're working with network communications, you're working with websites, you're working with the hardware or with CPUs, computer architecture, and it just keeps changing again and again with each case, with each client. You're just trying to understand what their business aspect does great and how that technology really drives the business forward and how law can help them.
So you went to law school set on patent law. Did you ever consider doing any other type of law once you got to law school?
Within law school, we had this course called Medical Innovations. Well, actually, we started, you know, basically a business within the medical field, but it was an interdisciplinary course where we're working with business students, we're working with engineering students, law students, and medical students all together. And so we start the project by going into the hospital and kind of learning what the doctors do and trying to figure out and isolate a problem that we can solve. And then we work with the business students and the engineers to actually solve that problem technically and build a business plan around it. And then, you know, as lawyers or lawyers in training, you know, we'll file the documents of incorporation. We'll see if we can't get patents on it or at least file a patent application. And then we will kind of start the development of the startup. And then at the end of the course, we'll pitch the idea to investors. And so the career was kind of working with startups and kind of developing their trajectory of moving forward as a company. And so I was thinking about that aspect of the career as well.
Was that your first introduction into patent prosecution?
Yes, pretty much. And then I had summer associate positions at patent prosecution boutiques, first year and second year.
Let's talk about that, the prosecution versus litigation. Did you have an idea going into law school which one you wanted to do? And how did you navigate exploring both options?
I did not know which one I wanted to do going into law school. And so I was like, I will do both as much as possible. And so working at the firms during my summers really helped me to figure out which one I like better. But with patent prosecution and patent litigation, you do have to understand how both work, because as when you work on the patent applications, you know, of course, you're writing the specification, of course, you're writing the claims, but to understand how they're litigated, that helps you to figure out how to write better claims, how to write better applications so that you can understand where the pitfalls are. And so I definitely enjoyed litigation a little bit more than patent prosecution and just the dynamics of it.
For students who are like myself, who are deciding between patent prosecution or litigation, what would you say is the key difference in the day-to-day type of work and what drew you more to litigation specifically?
That's a good question. So with litigation, well, with patent prosecution, you're interfacing more with like the engineers, both patent litigation and prosecution, you're going to understand the technology. And then with prosecution, you are focusing next on the patent and trademark office and interfacing with them as much. Whereas litigation, you're in court, you're, interfacing between opposing counsel and and going through the vehicles for litigations. There are two different tracks versus like a scheduling, where litigation is it's up and down schedule, where patent prosecution is more about deadlines 3 months, 6 months out. So the schedule is a little bit different between the two. But as far as a student coming into both, I mean, it's better just to try both to see which one you like and to understand like how both of them work together. Then you'll be able to see like, oh, I like this one better, and I like to stay, more with litigation versus prosecution, or more with prosecution versus litigation.
How do you think both areas will evolve as technology evolves?
That's a great question. With litigation, actually, even with both, because there are more technology tools that you can use to help you with your practice. Particularly, there's just software to help you, like perhaps check your claims, to do more research on how different patents, divisional continuations all interconnect together, particularly as more people are filing patents across the world. And now that our United States and other countries' systems start to kind of mature together. If you file your patent application here in the United States, that can also, your disclosure requirements are going to be similar to other countries, because now we're a first to file country, which is on par with the rest of the world. And so you can use different software to figure out how it interconnects. Your patent applications, your patents interconnect with the rest of the world. So in that sense, the technology will be helpful for a patent attorney. And as far as litigation, you can use those same software techniques to figure out how the different dates, the priority dates, prior art is helpful. And so dates become a huge thing within litigation, and like for different claims as well. And so you're always trying to figure out, okay, when was this claim disclosed? Does it have support in your provisional application? Everything. Trying to figure out as much information as you can. And the better tools you have, the more information that you can actually extract and kind of like have at your fingertips.
Yeah. I mean, even for us in law school, they've been introducing like artificial intelligence in legal research, which I think takes a lot of the grunt work out of litigation.
Absolutely. So you just become more efficient when you do things, which is great.
What are some other trends you see in the field of patent law? Like, for example, any sort of trendy type of technology or more PTAB proceedings versus trial work?
It seems like even the PTAB over the past 10 years, they're starting to mature. So for instance, when the PTAB first, like the IPRs first were enacted and were brand new, everybody filed an IPR. And so in the beginning, it was known as the death squad, because that's where your patents would go to die. But now, as the industry matured, people have an understanding of what they're supposed to do and the expectations when you file an IPR. And now, patent claims are hopefully getting stronger. The patent applications or the specifications have more information in them. And at the end of the day, you can see that if you're going to file an IPR, you have to be careful, because you have to make sure that you have all of your prior art that you can find or should have found within that IPR. And then the judges are able to make better assessments on whether or not the patent is valid or invalid. And then it goes up to the federal circuit, of course. So it seems like the PTAB is starting to mature around the IPRs. So yeah, things are just moving forward. And another instance is we're getting more judges in Delaware. So hopefully that starts to balance out where companies are filing patent suits. And I mean, they're still filing in Texas, they're still filing in California, but it seems to be, it's not concentrated as much in one particular district as it used to be. And so it seems like it's kind of spreading out between 5 major districts: California, Texas, Illinois, Delaware. I'm trying to think of some other ones. So yeah, so we'll see how things continue to progress.
Yeah. Do you travel often?
Oh yeah, definitely travel, particularly whether it's depositions, whether it's different courts. Yeah, you're always on the move.
And how often do you go to trial?
How many trials have I had in the past 5 years? It's almost been 3 or 4. Like I've got 2 coming up this year. Yeah, since 2020, it's been a trial pretty often. Not every year, but there's been a couple of them.
Yeah, 2 is a lot coming up.
Yeah.
How would you describe the feeling of going to trial, like all of your work culminating into this one like week?
Yep. Yeah, it can be nerve-wracking, intense. The interesting part is, and my prior firms kind of really coached us for this. It's basically you want to have the mindset of when you are introduced to a case, you plan to take it to trial. And so you're always preparing, what do the witnesses, how will they stand up? What about the technology? How would you present this to a jury? What's going to be the key piece of information? And so you're building all of that story for your, 2 weeks presentation. And so you're kind of excited too. Like, hey, I really want to present this in front of a jury. And I know it's going to be technical. I know it's going to be complex, but we're able to boil it down into a story type presentation that we believe that they'll understand. We have credible witnesses. We have witnesses that are going to tell their story and how they put their blood, sweat, and tears into this technology. And they're going to have to decide these simple issues on whether or not the patent infringes, whether it doesn't infringe, whether it's invalid. It gets exciting.
How would you say the process in crafting your arguments is different when you're presenting to a jury versus the PTAB?
Ooh. Well, it's different because the jury usually does not have a technical background and they're not astute in the law per se, and they may have like a limited time to actually look at this information. Whereas the PTAB judges, they're going to have a technical background. They're going to know patent law. They've heard these arguments before, so they have experience in what both sides like to argue and what the issues are and the technology. And so they know exactly what the issue is. They're going to go, okay, I need this information. I don't need this information. And so they're able to make decisions quicker and more efficiently based on the record. And so you're crafting your argument. Basically, it's almost like a bench trial in front of a judge that knows what the issues are. They've read the briefs, they know the technology, and so they're ready to go. Versus a jury, it's kind of like they're looking at the credibility of the witnesses. They're looking at the story. They're looking at the lawyers and how they present their case in court. So it's a totally different feel.
Kind of the stereotypical every law student who's interested in litigation's dream, kind of what you see in the movies, that oral advocacy in trials. How does your work actually evolve from when you start out to when you get to the point where you start to be able to speak in trials and take that kind of initiative?
So as like a young lawyer, you're basically trying to figure out what the case is about and all the details and how it works through litigation. Whereas when you're a senior lawyer, you're more thinking about the strategy and the overall picture on how this is going to present to a jury. Like, what are the key issues? And then you also have to balance your client expectations. So that's always probably a big thing versus being a senior attorney versus being a younger attorney. And it's kind of thinking long-term, short-term, and different strategies on what you want to do at the end of the day. And so as you present to a jury, you always have to be careful of, how does this look within the jury, but also to the client and the outside world. I mean, because at the end of the day, the trial is not an end all. And so sometimes you may play the long game, like, oh, we're trying to get to the appeals court, or, this may be a business strategy that the client is using at the end of the day. So it's definitely tactics and strategy versus as a younger attorney, you're trying to learn everything you can and trying to understand how things work.
Do you have any advice for people in law school or maybe even new attorneys for classes that they can take or organizations to join or extracurriculars that you'd recommend?
Oh, yeah. So for classes, I mean, it's definitely great to take like a patent law class, particularly as things get more complicated. I mean, because like even with litigation, you have district court, you have International Trade Commission, now you have the PTAB. And so those are 3 venues that have their own set of rules and they're all different. And so just being exposed to them and kind of understanding how they work would be a great class to take. And then let's see, as far as organizations, there's also the American Intellectual Property, forget that acronym for it.
Law Association, AIPLA.
Yes, AIPLA. That's the big national one. And then there's also local ones because like there's the IP and of court, like particularly here in the Bay Area, there's the Silicon Valley IP organization. And there's also organizations kind of outside of IP that you could also get involved with, which is great. Like particularly here in California, there's the California Minority Council Program. Like next week, there's Asian American Bar Association that's happening. And so there's many events or many organizations. And then you can also do nonprofit as well. well. And so there's great IP nonprofits as well. And I believe the USPTO has their own kind of pro bono organization or arm. Yeah, there's lots to be involved with.
So I like how you mentioned some groups with a DEI focus. I'd love to talk a little bit more about that. Do you have any advice specific to students with diverse backgrounds that are looking to enter not just patent law, but the whole legal field?
Yeah, absolutely. I mean, there's many opportunities to be involved, particularly with students with diverse backgrounds. Like, for instance, there's the California Minority Council Program here in California. There's also Adapt Legal, which is another opportunity to be involved in. And so there's the Minority Council Corporate Association, or MCCA. That's also you can get involved with. And then there's also, like I said, American Bar Association. There's the Charles Houston Bar Association. There's the Hispanic Bar Association. And so with all of these organizations, there's plenty of opportunity to actually network, connect with different types of folk. And a lot of people are in these organizations. And so they're well, diverse organizations for everybody.
Talking more about background in a bit of a different way, in terms of having a hard science background, obviously, in order to be registered to take the patent bar, you need to have a certain type of degree. But for patent litigation, do you think it's just as important to have a technical degree? Where do you think that comes into play?
It does come into play, particularly with litigation, because you have to understand technology. And particularly as clients get more complex features, technologies, their products, it's helpful to have hard science background to understand what the business is about. But, it's not necessary, but it's definitely helpful, particularly as you get down into the weeds and help with whether it's trade secrets, infringement theories, and validity theories. It can be complex. There's also economic majors that are heavily involved, and they can also get into the technology. And another thing, they can also be used with damages as well. And so damages is always important, because at the end of the day, if you infringe or if you don't infringe, is there any money that exchanges hands? You're always looking at the value of these patents or this technology.
What's your approach with technology in a field that you're not very familiar with?
Buy books. Buy as many books as you can. YouTube is great. And then most of the time, you can find like white papers or research papers that'll help you understand what the technology is about. And you start reading those, you start watching the videos and kind of get an understanding how things work. And then you just kind of work through it as much as you can. Talk with people, talk with the experts on how the technology or anything works. Because there's massive amount of information out there.
An overwhelming amount.
Yes.
What is the coolest technology that you've worked with? Do you have a favorite invention that you've gotten to work on?
That is a good question. I definitely like the virtualization systems that I worked with before. I just thought it was cool technologies because I've used the technology probably back in the 2000s. And this was through, I think, Citrix or virtual machines and emulators, particularly if you have a computer and you wanted to partition it into 3 computers. How would you do that? You would have like a virtual desktop, and then you would have different virtual machines running on a particular host. And so once you get to understanding on how that technology actually worked, it was pretty cool. It was pretty amazing. So, and then video games. I always like video games and understanding how they work as well. I'm hoping I can get maybe a virtual AR type case.
Yeah.
That'd be awesome.
With Meta and the Apple Vision Pros, I'm sure something is coming your way.
We'll see.
Okay, so to close out, I'll ask, is there a lesson or a piece of advice from your entire career that has stuck with you or you believe has been the most valuable?
Oh, communication. It's best to communicate as much as you can, whether you're looking at a technology and just explaining to somebody or just kind of talking with them to make sure you have understanding how things work. That's always big. Kind of back to the question, if you're in understand a new technology and you don't understand how it works, it's best to buy books, read YouTube videos, everything, and just try to understand it as best you can.
Amazing. Well, thank you again for joining us today. This was such a lovely conversation. And thank you again to Ashley and VPG for making this happen. I'm sure all of our listeners are going to really appreciate all of your insights and your journey. So yeah, thank you, Mike.
Thank you. Thank you, Kiana. Thank you, Ashley. This has been great. And the Water Cooler podcast, this is fabulous.